Nancy Adkins with Adkins Family Law. Listen, welcome to my live Q&A. We try to do these sessions once a month, and we try to get as much questions as we can from our viewers. So we're going to take the next 15 minutes live and try to answer some questions online. And if there's anybody that's watching right now, if you have a question that you want to ask me while we're on for the next 15 minutes, if you could just go ahead and post that in the chat, and then we'll have our fabulous technical crew pick up your questions and see if we can't get those answered for you live. And while we're going through that, we'll go ahead and pick up some of the questions that we've been picking up from the followers. So we've been getting some interesting traffic from some of the followers and some of our previous posts. And so in the interest of being timely and making sure that we are on top of what's the top of your mind, we've got some questions that we put together for the people who have been asking me from prior posts, making the comments. And so I'm going to go ahead and start with that. And then if you have a question or something gets prompted with you while you're listening, then please just throw your question out into the chat. Even just say hi if you want to say hi, so I know that you're here. And we'll go ahead and get started. And we've got 15 minutes. So if you can think of something between here and there, please let me know. So, all right, let's go ahead and get started with, this was an interesting question I thought was, we were talking about how to get that passport for your minor child when the other parent is absent or MIA, or, they just can't be found. I was working on a case yesterday, and they've got a little boy, this beautiful little boy, he's 4 years old, and he has no idea who his dad is. What do they do if they need a passport, right? So that's what we talked about just a couple of weeks ago, is how to get that passport and get an exceptional affidavit done. And then somebody commented off of that, and they said, listen, what if I'm doing this special circumstance affidavit to get the passport? What if I want to change my child's name? Should I change the child's name and then do the passport? Or should I do the passport and then change the name? And I thought that was an interesting question, because I think what's important is, the passport for a minor is 5 years. So you've got to get that up. I think it's 5 years. It might be 7. Don't quote me that, but there's a much shorter turnaround with the passport and the minor child. And so if you're getting the passport for your minor child and you're thinking about a name change, or sometimes there's an adoption, sometimes it's just a name change, but there's a lot of scenarios that will present themselves when parents are in a situation where they're going to be going through a name change with a minor child. So probably the best thing for you to do, if the passport is at play, is go ahead and get the name change done, or get the adoption done, or whatever that is, whatever that life circumstance is, or life event that's causing you to have to get into a name change for the minor child. Then I would get the name change done, and then I would proceed to go ahead and get the passport done. Because if you do the passport first, you have to always track the passport and the court order that allowed you to do the name change. So you always kind of have to keep them both together. Whereas if you do the name change first, you do the name change, you get your court order, and then you can put it away. You show the name change to the passport office, and then you're just on a passport. So it's a lot easier that way if you do the name change first and then do your passport option. So good food for thought for you guys. So I appreciate the question. And guys, let me know if you have any other follow-up questions or further questions relative to that situation. I just know there's a lot of parents out there trying to get a passport, especially with the summer coming up. So hopefully that's a good one for you guys to track down. Okay, so the next one is we had a follower comment about if he's hiding his identity and you both don't communicate with each other, and he's not allowing me to take my child to another country to visit. So, this always goes back to whether you're in touch with the other parent or if you're not in touch with the other parent. So if you are in touch with the other parent and they're just, we have this conventional wisdom about, people can say no and they might have a good reason. And sometimes they say no just to say no. It's like the next child throwing the tantrum, right? God, if you're a parent, you know what the child looks like when they're just having a meltdown, right? But guess what? It happens to the other parent too. So if you're dealing with another parent who's having that meltdown or having that, trauma drama with the kiddo thing, then that's a different situation where you have to show to the court that they're saying no just because. And that's really not having a reasonable basis for why they would say no. So you do have to take that to the court and show them that they're just being unreasonable. It's just, I always go back to, it's just a tantrum. Because honestly, if you're having good communication with the other parent and they're talking with you about the basis for why they don't want to, and I think it's interesting with the passport, it's harder to argue the passport. Usually you can get the passport. So let me tell you that. You can usually get the passport. And sometimes the other parent just makes it that much more difficult, but it can be done. So I guess that's the short answer to, if you have the parent and they are present and they're just being difficult, it's a different way to get there, but you can still get there. So you're going to have to go into court and show that it's a bad faith reason as to why they're giving you a hard time. And then, hey, you know what? If they're just giving you a hard time and acting in bad faith, then maybe go get fees, so that's that we really want to motivate them to really try to behave properly. So that would be the answer to that. If you've got that parent that is not cooperating and they're in bad faith, then you might want to consider putting a motion into court and showing the judge that they're just being difficult with you and throwing a tantrum and having a meltdown. It happens to the parents. Anyway, all right. So I have another question then here too that talks about terminating the parental rights of the other parent. And this is kind of a tricky thing then too. So the short answer is you can terminate the rights of the other parent. And there's a couple of things that are going on. If the parent is not around and they've been MIA for quite some time, then it's much easier to do versus the other scenario that we're talking about, where you got a parent who's just totally being difficult. I got parents that call my office and they're like, hey, listen, I'm trying to get out of my child support obligation. Could I just terminate my rights? Could I just give them up? And the short answer is no, you can't. It's your baby. It's your kid. You're fiscally responsible for them. You have the obligation for them financially. And, the other issue is, are you going to step up as a parent? And we're not going to force you to do that, but you're certainly going to be responsible for your kid. And then if you're the parent who is not around and just not happening, then that's a lot easier to do. So you can just really, depending on the amount of contact that you're having with the other parent, you might be able to do that. And then the second thing that's going on with that, so we're talking about terminating the parents' rights. Are they active in the child's life? Are they not active? So those are a couple of considerations that you have to think about and get those questions answered. And then the second thing is, if you're interested in terminating the rights of the other parent, the net effect of that is taking one parent out of the child's life. And I'm just a firm advocate that the child needs two parents in their life. So you don't really want, forgive the expression, but having two parents is part of, it's not legitimizing the child, but the child has two parents. And if you try to terminate the rights of the other parent, then you're basically bastardizing your child where they're just a solo parent. So if you're thinking about terminating the rights of the other parent, it can be done. My suggestion would be that you have someone else step into that role of the second parent. So whether it's the new person in your life, if it's the new person that you married, if it's actually someone else, a friend or somebody that that wants to step into that role. So the child should always have at least two parents in their life. And then they're also getting different perspectives from both parents and not just one parent, and this is the way things go. So you certainly don't want to have that as well. So it's always good to have the two parents. And if the first parent isn't working out, we could potentially put another parent into that role. But you'd have to think about having who you want to step into that role. And then also knowing that just like terminating the first parent's rights, that other person stepping into the parent's role, it's permanent. So it's not a take back. You can say, you know what, let me take it out for a spin. Let me try it. Let me see what happens. They've got to know that they're going to step up and be the parent, which is kind of a cool thing. If you really are the single parent raising a kid, this is maybe something that you do want to think about, because God forbid something happens with you. What happens with your kid? That's a big question. So this is one of those mechanisms that you can put into place. So there's always a backup. There's always somebody else involved or somebody in that place, in that role, and somebody that the kid's familiar with. It's all too common that we have kids that lose a parent or lose both parents. I just talked to somebody at the beginning of the week and they said, yeah, it's sad, but we had a situation where both the dads had overdosed. And then there was an issue with the mom. So the mom was raising the two kids, and she lost the bio dad. She lost the birth fathers in that instance. And then something happened with her. So now it's actually stepped into, I believe in that situation, there might be the grandmother, but that's usually what happens is, some extended family member steps into that role. So don't wait for something to happen. If you're the single parent and you need to have a backup plan, then maybe that's a way for you to go, whether it's going to be a sibling or whether it's going to be a parent or whether it's going to be an adult child. Sometimes in these blended families, you get an adult child that might step into that role. So a little bit of proactivity goes a really, really long way. If you're the single parent and you want to know what's going to happen with your kid, God forbid that something happened with you, get a plan in place. So it's another reason why you wouldn't terminate the parental rights of the other parent, because they could potentially step in. It takes a little bit of thought though. Okay, so that is terminating the parental rights and kind of the missing parent. That's kind of been the theme of those last few questions. And then here's another question that came up. And again, this is really good because of the summertime coming up. Parents consider relocating with their kids, which you can do, but you have to petition the court. Even if you have agreement of the other parent that you're going to relocate, and then the relocate is 50 miles outside of where you already live. So if you're just going to move, 10 miles, 15 miles, 20 miles, that's not a big deal. It becomes a situation where you're going to move a really, really far away. You're going to move a big distance, and the distance on the statute is 50 miles. So if it's more than 50 miles, you will have to file a petition to relocate. It could be easy if the other parent is in agreement with you relocating and you facilitated the ongoing relationship with your child, then you just have to submit your agreement to the court. But that's the hinky, is that you have to submit the agreement to the court, because if you relocate without the agreement, there's a lot of, it's a pretty strict statute as far as relocating and making sure that you comply with the requirements of the statute. So definitely, if you're going to do a relocation, make sure you consult with an attorney to do that, because it just, I've seen some pretty stiff penalties, and kids get picked up and returned to the other parent because the relocation wasn't filed correctly, or it wasn't filed. That's the other parents just relocate and they think it's okay to do, and you can't. I had I had a judge who just transferred the case out, and he said, listen, you didn't relocate, and both the parents had relocated to different areas. And the judge said, you know what, neither one of you belong here anymore. So the judge got the case transferred out. So for what it's worth, there's different things that are going on with these relocation pieces. So just make sure that if you're the parent and you want to move, that you at a minimum file your agreement with the court. And then if the other parent doesn't want to agree to the relocation, then it's a matter of setting down the petition to relocate and then making sure that you get the permission from the court to relocate if there's an objection from the other side. So that actually has to go to a hearing. Okay, so I think also there was a question then too. So I don't know if, let me just see. So here's an interesting question then too. If some people are trying to leave the state and some people are trying to come into the state. So if you're trying to come into the state and you've got a court order from New Jersey or New York or North Carolina or California or, Oklahoma, if you have a court order from another state and you're coming into South Florida, then you absolutely want to get that court order registered. And I would get it registered here in South Florida. So the court order can come with you. Just make sure that you get it registered. You could register it for enforcement. You could register to modify it. It just depends. So you can certainly enforce that New York order here in Florida. You just have to make sure that you get a certified copy of it, and make sure it gets registered with the Florida courts so that it can be enforced. If it's alimony, if it's for child support, you can change it up for time sharing. There's things that you can do differently. Just make sure you get the court order registered here in South Florida. So that way, and then it's almost like you didn't even move, if you will, but everything comes with you as far as portability. So you certainly can enforce your out-of-state custody order here in South Florida. And then the last question, and this is just a quick one. I think it's going to just be a short one because we're running out of time. The last question that I can address, at least for today, is whether you can modify the child support order, and probably usually there's a few variables on that. There has to be a substantial change of circumstance, and usually the ways we measure it is based on, you know, whether somebody's income is different, if it's gone up, if it's gone down. And then we also look at whether the time sharing has changed, which will help to modify the child support. But usually there's a financial difference in the child support order. Sometimes it's just been 3 years, so it needs to be looked at again. So there's a lot of different ways that you can modify the child support order. And I don't think that that's a short call. I think, in my opinion, it's a short call to a family law attorney that you can sort of bounce through your options. The biggest thing is the substantial change of circumstance. So make sure that you speak with a qualified family law attorney to make sure that you can. And there, like I said, there's a lot of different ways to do it. And then just figure out what's going to be working best for you guys in your situation. So probably can get your child support modified, but talk to somebody about that. All right, guys, listen, I'm out of time, at least for today. We're back again next month with more live Q&A. So please keep your questions coming. Keep flowing in the chat. Keep following me on my social media channels down below. We've got all that stuff listed for our guru here. So follow me on my channels. Keep the questions coming, and I'll see you guys again next month. Take care. Bye.